the new developments in the Karen Reed murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Reed was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him?
I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
And once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Reed. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Reed was drunk and reckless when she hit John O'Keefe.
It's not just Reed being sued here. The family also suing the two Canton bars from that night.
The two bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Reed is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they are coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
The second trial of Karen Reed is still on schedule to start next month, despite both the prosecution and the defense requesting that it be delayed until April. Judge Beverly Cannoni has yet to rule on the joint motion to postpone the trial, and the pretrial hearings are moving right along. These hearings and the motions being filed by Hank Brennan, the special prosecutor brought in from the outside to prosecute this case, have given us a glimpse into how different the new trial may be from the previous one. I went over the motions that were filed in the previous episode, including the prosecution's motion to have more testing done on Karen's SUV, and they're seeking the phone records for Karen's dad, as well as the defense's motion to have the sidebar conversations from the first trial to be made available, and their request for DA Michael Morrissey's personal email and phone records. Now, some of these motions, along with some others, were argued in the latest hearing in front of Judge Cannoni, and she's already issued the decision for some of them. So, let's jump right in. The first motion in the hearing was from the defense. It was a pro hoc vice motion, which is basically just asking the court to allow a lawyer from another state to practice in this state. This is usually just a formality. It's not often challenged as long as the attorney is in good standing. Defense attorney David Yannetti says that attorney Robert Alessi is one of the best attorneys in the country, and he believes that he will add value to Karen Reed's defense team. Now, Yannetti also said that Alessi has specialized skill and knowledge in representing defendants in matters of this nature. Now, look, pro hoc vice motions are rarely challenged, but after Yannetti said this, Judge Cannoni went back and questioned that phrase, asking Yannetti to explain that sentence further. Now, Yannetti answered by saying that Alessi has decades of experience in the courtroom, both on a trial level and an appellate level, and he said that he knows of no better trial attorney in the country. I was curious, or nosy, so I pulled up Alessi's information, and something that stood out to me was his experience with criminal matters. Now, according to his firm's website, Alessi has pursued and defended on behalf of clients several Section 1983 actions involving claims of violations of constitutional and other rights by government officials and agencies. Now, read that again. Violations of constitutional and other rights by government officials and agencies. Now, that's interesting considering what's gone on in this case with the allegations of misconduct of some of the government officials and agencies involved. And I can't help but wonder if that's why the further clarification was sought by the judge. Regardless, Judge Canoni said that she would take the motion under advisement, and she issued her ruling later on in the day, allowing Alessi to join Karen's defense team. Next up is the argument over the cell phone records for Karen's father, William, or Bill Reed. I mentioned in the last episode that the Commonwealth filed a Rule 17 motion where they were requesting the Verizon records for Mr. Reed. I've already been over the argument according to the filings on both sides, so I won't go through the entire argument again, but I do want to mention a few things here. First, not only are they requesting Mr. Reed's records, but they also have filed a Rule 17 motion requesting the phone records for Karen's mom, Janet Reed, as well. So Brennan says that it's the prosecution's burden to prove that Karen Reed knew she hit John O'Keefe, which is absolutely true. You can't prove second-degree murder unless you can prove that Karen intentionally hit John with her car and knew that she hit him. Now, they obviously didn't accomplish this in the first trial. The jurors all agreed on that, as we heard from multiple jurors who've come forward. So if they couldn't prove it before, now the question becomes, how do they do things differently to try to prove it this time around? Brennan says that to meet this requirement, they only have to prove that she intentionally drove, which resulted in her hitting John, and she knew she hit John, which had a strong likelihood of resulting in death, but she left the scene and did not get him help. So Brennan is requesting the phone records for Karen's parents because he claims that she called her parents around 1 a.m. that morning, and the inference, he says, is that it's because she knew she did something wrong.
Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind.
As a quote-unquote 40-something-year-old woman, I can tell you that the inference that he's making is a huge leap. Saying that Karen calling her parents shows that she hit John and knew she hit him and left him anyway seems like a big stretch here, especially when you take into consideration that she also called John multiple times and left him angry voicemails demanding to know where he was and yelling at him for not coming home and leaving her there with the kids while he's out doing whatever she believed at the time that he was doing. Also, if Karen was drunk and angry, like those voicemails to John show, it's not surprising that she would call her parents too. Think about the one voicemail to John O'Keefe just minutes before she called her mom, where she's angry and telling John that she's going to leave the house and his niece will be alone, so he better get there. Now, Karen wasn't a parent. And we heard during the first trial that she often talked to her mom and dad about how she handled things with John's niece and nephew because she didn't have parenting experience to rely on. So if John's not answering his phone and he's not coming home and she's saying that she's leaving, couldn't an inference also be that she's calling to ask her mom's opinion on what to do, if she should stay or leave? It seems to me like there are inferences that can be made, but saying that the inference is guilt, it just seems like a stretch. Judge Canoni asked Brennan why he needs the records if they already have Karen's phone records that show if and when she called. Brennan says that the search warrants for Karen's phone are only for the day prior, and he's wanting to have the records from 1 month prior. He says that Karen was, quote-unquote, panic calling her parents at 1:30 in the morning, and he claims that records can show that it wasn't normal for her to call them that late. Then he explains why he says this is important.
Here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, But I expect the government is pursuing a witness. And my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in.
So the Commonwealth is planning on bringing in an expert that Brennan suggests will say that John could have been saved if he had been helped medically within the first couple of hours. Now, he's using the calls that Karen Reed made to her mom's cell phone around 1:30 a.m. as some kind of proof that she hit John and left him. Like I said, it's a stretch. There's also some confusion about the calls that were made and when they were made. So the unanswered call was actually at 1:14 a.m., and it was made to Karen Reed's mom's phone. Now, this was right after Karen had left a voicemail on John's phone, yelling at him that she's there with his niece and nephew and calling him a pervert because she believed that he was out cheating on her. She's literally calling him to yell at him because she thinks that he could be out with another woman. So, to me, it's not logical to think that the very next call that she makes, just seconds later, is to tell her mom that she thinks she may have killed him. Now, the other two calls to her mom's phone were made at 4:38 a.m. and 4:42 a.m., which was right after Karen woke up John's niece in a panic and right before she called Katie Camerano. Both of those were also unanswered. The first conversation with her dad was not until after John was found in the yard at 34 Fairview. Brennan is seeking both parents' phone records and has said that he wants to use Janet Reed's records to impeach Bill Reed's statement that his conversation with Karen was something that was said in the hospital when she said something about how she believed she hit something. So, as a reminder, I mentioned Brennan misquoting the Ted Daniel interview. He said in his filing that Ted Daniel asked Mr. Reed about his first conversation, not conversations, with Karen. And he basically used this as a gotcha moment because Mr. Reed discussed this conversation that happened in the hospital. Now, Brennan said that that wasn't their first conversation. Well, when arguing the motion, Brennan brought up this difference in conversation or conversations and basically kind of just brushed off the whole misquote thing like it meant nothing or didn't matter. But it absolutely matters because it changes the whole meaning. The first conversation is not the same as the first conversations about what happened. Also, using Janet Reed's records to impeach Bill Reed doesn't really make a whole lot of sense here because they are not interchangeable. They're not one and the same. So you can't say that she talked to her dad when it was her mom's phone that she called. And those calls were unanswered anyway. But regardless, that's part of Brennan's argument. Now, attorney Liza Little argues the opposition for the defense, and she says it's an invasion of privacy for the Reeds for information that isn't relevant to the Commonwealth's case. Also, Miss Little makes this point.
And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
Okay, so this is a huge point. Judge Canoni repeatedly denied the motions from the defense to get the phone records of other people who were actually present that night, like Brian Albert, for example, because of privacy. So if that was the logic for Judge Canoni to deny their request, she's saying it should also be the logic applied to deny the Commonwealth's request. And she also makes the point that Brennan didn't give the full context of the interview between Mr. Reed and Ted Daniels. Now, Mr. Reed does say something about Karen telling him in the hospital that she hit something, but he goes on to say that what she was referring to was John O'Keefe's car in the driveway when she was leaving that morning, which, of course, we've all seen on the video from the ring cam. Ms. Little also argues that this is a fishing expedition and that the prosecution only wants these records so that they can go through and look for something else that they can use when it comes to Karen's parents. She also argues that the legal requirements that the Commonwealth would have to meet in order to get this approval hasn't been met. So, she says it is mandatory for the judge to deny their request. Now, 3 days after the hearing, Judge Canoni issued her ruling on the phone records for Bill and Janet Reed. The ruling states that despite the detailed arguments articulated in supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lampron and the Massachusetts law. So, the request for Karen's parents' phone records was denied. We'll be right back after this. This show is sponsored by BetterHelp. One of my favorite part of the holidays, the thing that makes me feel the most cozy, is curling up with soft Christmas blankets, with the Christmas lights on, and watching Christmas movies with my kid. How do you stay cozy during the holidays? For some people, it's Christmas movies like me. For others, it's hot chocolate or time with your family that brings that sense of coziness. Therapy is a great way to bring yourself some comfort that never goes away, even when the season changes. Therapy is helpful for learning positive coping skills and how to set boundaries, which can also come in really helpful around holiday season. It isn't just for those who've experienced major trauma. Therapy empowers you to be the best version of yourself. If you're thinking about starting therapy, give BetterHelp a try. It's entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist and switch therapist at any time for no additional charge. Find comfort this December with BetterHelp. Visit betterhelp.com/juror today to get 10% off your first month. That's BetterHelp, HELP.com/juror. Next up is the prosecution's request to obtain the audio from an interview that Karen gave to Boston Magazine that Brennan says is incomplete. Now, Brennan claims that while Karen was giving this interview, there are times when her attorneys would interrupt her and the interview would pause, and when it went back on the record, her answers either shifted or had changed. Now, Brennan wants what was left out of these gaps and says that they include admissions of guilt. So here's the deal with this. Reporter Gretchen Voss, who was in the courtroom every day of the trial, also did an interview with Karen last summer. I've referenced it before on different episodes. So the prosecution is wanting all records, the complete audio recording, all handwritten notes of any conversations between Gretchen Voss and Karen, including anything off the record, all the emails between them, texts, any voicemails, all of it. Now, the last time that prosecution sought this, Judge Canoni ruled that the information that was on the record is what they were entitled to have, but she left it open so that they could request more if they believed after getting the redacted version that they were entitled to more. So now Brennan is saying that they want the judge to reconsider and give them more of the information that was redacted before. There are two audio recordings between Karen Reed and Gretchen Voss. The first one had about 50 redactions, and the second one had twice that. Brennan says that these redactions occurred during discussions and admissions pertaining to critical issues in the case, and many of them include interruptions from Karen's attorneys. He says that when the attorneys interrupt, conversations that they were not given occur off the record. And then after the redaction, the interview will start back up and the topic is diverted or redirected to a different topic. So here's the thing. Since there's a reporter present, there is no attorney-client privilege here for these interviews. When you have a third party present, the attorney-client privilege goes out the window. Also, Massachusetts doesn't have a law that shields the court from seeking journalists' off-the-record interview audio and notes. There's no reporter privilege in Massachusetts. Now, in the previous ruling, when we went through this before the last trial, Judge Canoni said that requiring Gretchen Voss to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. Brennan basically tells Judge Canoni in his filing that isn't something that she should be concerned with. He says that Voss shouldn't have made a promise to Karen Reed to keep anything confidential. He also says that the judge acknowledged that this case has extraordinary public attention and scrutiny, but he says that's because of the defense anyway. He acknowledges that Gretchen Voss has filed an affidavit saying that she fears for her safety, but Brennan claims that any fear that she has in relation to the safety of herself or her family was developed in part by the defense's strategy and has no legal bearing on the issue. Brennan also says that with all three of Karen's attorneys present for the interview, that could potentially make them witnesses, as in her attorneys, which would in turn mean that they weren't able to defend Karen Reed. Now, he says that the Commonwealth doesn't want to be, quote-unquote, heavy-handed by doing that. So he says the easiest and simplest thing is to just give him what he wants without making the defense counsel all witnesses. Wow. So attorney Richard Birch represents Boston Magazine, and he argued against the prosecution's request to have access to the additional audio recordings and notes. Now, Birch says that Gretchen Voss has suffered harassment and still fears for her safety, and says that she will suffer more if she's forced to turn over her notes. Side note here, Brennan made a comment about how he's never seen so much witness intimidation in any case before or something like that. Y'all, he was an attorney for the mob, and you've never seen witness intimidation like this before? But I digress. Anyway, Birch also argues the handwritten notes are her own personal thoughts and may lead to her being called as a witness in the second trial, which he says is a whole new rabbit hole. Like I said, Voss was there every day in the courtroom during the first trial. So if she's made a witness in the second trial, then she won't be able to be in the courtroom as a reporter because of witness sequestration rules. Now, Judge Canoni took it all under advisement, and just as I was getting ready to publish this episode today, her ruling came out. I checked the court docket this afternoon, and it wasn't there. Gave it one last check before posting, and now here I am adding it into the copy. So Judge Canoni ruled in favor of the prosecution here. So all audio recordings, interview notes, emails, text, and voicemails in possession of Gretchen Voss and or Boston Magazine are now subject by court order to be turned over. Let's hope that she hasn't destroyed her phone on a military base. Boston Magazine isn't the only news outlet that Brennan is trying to get information from. He's also seeking the complete video and audio record of all interviews that Karen Reed did for Dateline, including anything that wasn't aired, and all of the handwritten notes of any conversation between Karen and Dateline's Dennis Murphy, or anyone else from NBC Dateline, plus all emails, text, and voicemails between Karen and anyone at NBC. So this one's interesting. Last year, before the first trial, the prosecution tried to get footage from NBC, but weren't able to. Now, Brennan says in his filing that the local NBC station, NBC Boston, has discussed the Dateline episode on air. And he says that they are also intimately involved in the promotion and distribution of Dateline. So, since the local affiliate is in Massachusetts, Brennan wants to have a court order given to them to produce what he's looking for. The local affiliate has agreed to send any of the promotional materials that they used for the Dateline episode, but they said that they don't have the full interview that Karen did with the network. Brennan also wants the full interview from local channel Boston 25, where Mr. Reed talks about his conversation with Karen that she said she hit something. Now, he says that he needs the full interview to be able to put that comment in context. And he also wants the interview that Karen did with ABC, including the parts that weren't aired. So here's the thing also with ABC. Now, Massachusetts, they don't have reporter's privilege. I mentioned that earlier. The court can subpoena for the conversations that are off the record. But New York does have reporter's privilege. And ABC and NBC are both based in New York. So Brennan wants this subpoena to be sent to ABC's office in Massachusetts so that they will have to comply with the request. But ABC's attorney argues that it doesn't matter which office you send it to. The company is still based out of New York, so they go by New York law, regardless of where the subpoena is delivered. Now, the full interview is expected to eventually air, so the attorney said that when it does, that should hopefully solve the issue. Now, all during his arguments for these things, Brennan kept saying that the interviews that he was wanting and the footage that he was wanting, that it was all full of admissions of guilt and confessions. Now, look, I understand it's an attorney's job to point out any kind of inconsistency that they can find. I mean, look, the Alberts, McCabe's, and law enforcement involved in this trial sure gave us plenty of inconsistencies in their stories for us to discuss. So it's not surprising that Brennan wants any and all footage of Karen so that he can try to find holes in her statements as well. But as far as the interviews being full of admissions of guilt, once again, to me, that seems like a stretch. The examples that he gave were definitely reaching, which, again, I know attorneys often do. But Karen actually addressed these accusations when she was leaving court after the hearing, saying that if she had confessed and admitted guilt to these news outlets, they wouldn't have just sat on that footage. It would be plastered all over the place.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's a fishing expedition. They don't exist.
I mean, she has a good point there. Now, as I was getting ready to publish this episode, again, the ruling on this one came back also. So Judge Canoni ruled in favor of the prosecution that Boston 25 is to turn over all written or recorded statements of William Reed, Janet Reed, and Nathan Reed, including all video recordings and any interview notes or memorialized statements made or adopted by William Reed, Janet Reed, or Nathan Reed. So again, the local affiliate has to turn everything over. So what's next? The sidebar transcripts that were requested are being produced, and they'll take about 6 weeks. The SUV testing was scheduled in Texas for December 2nd, and then the testers were set to return to Massachusetts on December 5th, and the results are expected around 7 to 10 days later. Another hot topic has been the personal work phones of Norfolk County District Attorney Michael Morrissey. So David Yannetti said during the hearing that he learned that morning that Brennan has gone through Morrissey's phones, both the work cell phone and his personal one. One of those phones was set to delete text messages automatically after 30 days, which, of course, Yannetti said raised some concerns. But Brennan did say that he has been preserving those messages as of the week before when he was tasked with going through Morrissey's phones. Now, also, because of Morrissey's ex parte communication with judges and clerk office employees, Yannetti wants Morrissey's emails searched for anything sent to an email address that includes a JUD in the suffix, along with a search for the names of any judges who have sat on this case and any clerk office employees. Now, this way, they can check for any other ex parte communications between Morrissey and the clerk's office and the judges, including Judge Canoni. Now, he would also like a search of anything with Reed, spelled R-E-A-D, as in Karen Reed's last name, and also anything with Reed, R-E-E-D, since that's how Morrissey spelled it in the ex parte communication that they did find already. Now, Yannetti said that he wasn't sure if this was spelled that way to avoid it coming up in a public records request or if he just misspelled it. So he would like to include both spellings in the request. Yannetti also says that in light of Morrissey's actions using his personal email account for the ex parte communications, that they have reason not to trust him, especially since public officials' use of their private emails for government business is considered a violation of state law. And of course, Morrissey would know that. So next up in the case is the Daubert hearing that's scheduled for December 12th. A Daubert hearing is where the judge can decide if the scientific reasoning behind any expert's testimony is relevant and reliable. So then they can decide if it should be allowed in for the jury to hear or not. The judge hears everything and then they kind of act as gatekeepers as to what the jury can hear. Now, it's important because you don't just want any rando off the street to come in and tell the jury that they know something because they're an expert, but then they can't back it up through reliable scientific reasoning. The first thing that pops into my head is Trooper Paul being cross-examined by Alan Jackson when he couldn't explain why the phone would have traveled with John and landed under his body. So his answer was, "It just did." That would be an example of unreliable scientific reasoning. Now, the Commonwealth wants the expert testimony of Dr. Marie Russell to be excluded. Dr. Russell had a very extensive CV. Her career history was incredibly impressive. When she was brought in as an expert for the defense, Lally tried to have her testimony excluded before. Judge Canton conducted a voir dire and determined that her testimony was going to be admissible but limited. So she was able to tell the jury that based on her knowledge, training, and experience, she believed the abrasions on John's arm were inflicted by either teeth or claw marks and were consistent with a large dog. Now, Brennan wants the judge to reconsider allowing this in. He says that Dr. Russell isn't qualified to render an opinion on the victim's injuries. Brennan says Dr. Russell is not a qualified expert in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behaviors. So he says that her opinion is not reliable. Brennan also says that Dr. Russell's experience with dog bites is mostly focused on the injuries sustained from law enforcement dogs, not domestic dogs. So he says the bite styles would be different in Chloe since she was not a law enforcement canine. Both sides will make their arguments on this on the 12th, so I'll have an update for you on this topic after they're heard in court. We'll be right back after this. Obviously, having a true crime podcast means I'm pretty into the whole sleuth thing. Even when I'm not doing it for work, I'm doing it to relax. That's why my new favorite game on my phone is June's Journey. It's free to download, and you have to find hidden objects in each scene. But the scenes are beautiful. You have a mansion on a garden island that you can customize and remodel as you go. And it's all really colorful, and it has this really cool 20s type style. There's always something going on, and you progress through the story to get to the next chapters. The one that I'm on right now is, of course, a murder mystery. There are also events you can do along the way that earn you additional in-game prizes. You can play alone or join a club where they have special competitions. I enjoy playing when I'm trying to wind down after writing, researching, or recording all day. I get excited trying to find the hidden objects in time so that I can get my next clue. And I'm always wanting to get to the next part. Plus, it really helps me wind down without feeling like just a mindless, time-wasting game. You can download June's Journey for free by clicking the link in the podcast description. June's Journey is available on iOS and Android mobile devices, as well as on a PC. So, we continue to approach the new trial date. And as we approach, both sides continue to file motions. They're each hoping to shape the landscape of the new trial by either including or excluding specific things that they think are relevant or aren't relevant. Also continuing is the online vitriol between the two sides, the ones who believe in Karen's innocence and the ones who believe she is guilty. The thing that is so interesting about watching trials is that everyone is looking at the same evidence. Each side looks at the evidence that's available and gives different interpretations of it. Now, sometimes that evidence is overwhelming, like if there's hard physical evidence or DNA or a video of what happened, etc. But usually, if there's an actual trial instead of a plea deal, that means that a lot of times the evidence may be more open to interpretation. The prosecution gets their shot at showing everything that they have. Any exhibits, witnesses, experts to explain things, whatever the case may be. They have a chance to take all of the evidence available and present it to the jury and give their narrative that they have developed from what they have found. And then the defense gets that same opportunity. And they usually tell two very different stories. It's so interesting to me how each side can take the exact same information and often paint a totally different picture. Each side may put more emphasis on things that they believe are important, especially the things that they believe support their version of events. And they may be very dismissive of the things that work against them. For example, in this trial, the expert testimony was a huge deal for me. Comparing Trooper Paul's train wreck of a testimony to the ARCA experts hired by the Department of Justice, that was big stuff to me. One of the main issues that I always had was understanding how those injuries could come from that car because the damage to each didn't line up. The ARCA experts clearly and confidently explained why it couldn't have happened like that. But Trooper Paul was unable to give clear explanations or to back up his conclusions with science and physics. That, to me, was a huge deciding factor. But Lally basically brushed it off. Then I think about Lally's closing arguments, where he emphasized the testimony, although it was conflicting testimony, about Karen saying, "I hit him," to the EMT worker. Now, Karen admitted to saying, "Could I have hit him?" but said that she was distraught and trying to figure out what happened. That was an intense, emotional moment full of chaos and fear. And the statements are very conflicting from different people about if she said it or if she asked it. And the officer who was supposedly standing there, and that's who they said that she said it to or in front of, or that he was told about it, he denied it. He denied it being said. And the police obviously didn't hear it or take it as a confession if they did hear it because they let her leave. So for those reasons, the argument of "I hit him" didn't really hold any weight with me. But Lally really relied on that in his closings, using that as a driving force to push the jury toward a conviction, claiming that she hit him, she knew she hit him, and here she is confessing on scene to hitting him. Now, when I'm analyzing evidence, I see the scientific arguments about his injuries, and I see the damage to the car not being consistent. I see the overwhelming issues with the law enforcement in this investigation. I see the huge pieces of taillight not being found during the first search, but then they were able to find clear cocktail glass. I see the inverted Sallyport videos being presented as true and accurate to the jury. These things are all things that weigh the heaviest with me. And the comment, "I hit him," or question, "Could I have hit him?" does not even come close to outweighing any of those things for me. The scales of justice are symbolic. They represent the weighing of evidence and arguments on both sides. Now, in my personal proverbial scales, the things that I give more weight to may be the things that someone else sees as irrelevant or not as important. I've seen juror interviews before after a trial where something that I thought was irrelevant was a deciding factor in that juror's verdict. Just like the defense and prosecution can look at the evidence and see or believe two very different things, so can we. That's why we usually have 12 jurors instead of 1. You'll often see prosecutors and defense attorneys chatting it up before court begins, or on breaks, or at lunch. But when court is in session, they may seem like the only thing keeping them from a backyard brawl is the demand for dignity and proper etiquette while in front of the judge. I've said before that this reminds me of how things work in sports. So when you're on the court or field, you're in game mode, eye on the prize. That's your enemy. But when the game is over, everyone shakes hands and still respects each other. Both sides remain civil. Unfortunately, it hasn't been like that in the world of social media that follows this case. I'm not sure what has made this particular case so polarizing, or why people seem much more unwilling to accept that we won't all see the evidence the same way. What initially drew me to this case was the passion behind the arguments from both sides. I wanted to know more about the situation because for people to be so convinced, only to have the opposing side be equally convinced of the opposite, that intrigued me. But the same thing that drew me to this case has also proven to be the hardest part of covering it as a podcaster. Somewhere along the way, the passion on each side turned turned to anger. The spirited debates have turned to vitriolic attacks. And instead of shaking hands with the opposing team and then going on about our days, online campaigns are launched to harass, humiliate, and destroy people who see the evidence differently. I have to say that based on the evidence that I have seen, studied, organized, and obsessed over, and the case that the Commonwealth of Massachusetts provided, I wholeheartedly believe that Karen Read was not proven guilty beyond a reasonable doubt. That's a very high burden of proof. And even after almost 70 prosecution witnesses, that burden of proof wasn't even close to being met in my eyes. This case is drowning in reasonable doubt. Now, I can't tell you what happened at 34 Fairview in those early morning hours in January of 2022. As much as we may form our own opinions based on the evidence that's been provided, none of us truly know what happened. What I can tell you is that everything that we have heard about John O'Keefe as a person has been positive. He was one of the good guys. When I think about what we've heard about John and his character and the type of person he was, it makes me really sad to see the chaos and hostility that surrounds this case. John was a proud Boston police officer. That means that he took an oath to support the Constitution and he believed in justice. He was also kind, a family man, and a jokester who loved to laugh. With all of those characteristics that we've heard about, I can't help but feel like he would despise what this trial has become. Part of believing in and honoring the Constitution and justice is wanting people to hear the evidence and weigh it according to their own beliefs and experience, without being ridiculed or harassed for their conclusions. And being a family man, I'm sure he would hate to see his loved ones being the targets of any kind of harassment. And being a kind, good man, I feel like he would be repulsed to see people justifying their reprehensible behavior toward others by saying that they're doing it in his name, especially since that's not the kind of person he was. As we approach the next trial, the social media storm is already brewing, and it will likely get worse once the trial is here. So, going into the second trial and the upcoming hearings, I would love us all to challenge ourselves to honor the victim by staying out of the circus of it all. We can focus on the evidence instead of focusing on the people who don't see the evidence the same way we do. We can feel anger about different things without letting that anger activate hostile, aggressive behavior towards others. We can disagree with someone's opinions or conclusions without trying to belittle, discredit, or attack them in an attempt to make our own conclusions somehow seem superior to theirs. None of those sound like things that John O'Keefe would do or approve of. So honoring his memory shouldn't include those behaviors, right? After all, in the end, both sides just want justice for John O'Keefe. It's just that they each have very different ideas of what that should look like. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.